schemes. So settled cases in January were 2,090, settled cases in November were 2,130. So they'd settled the grand total of 40 cases over the course of last year. That's 6 days a case. On that basis, it's going to take them 6.5 years to clear the remaining 287 cases. That's August 2032. Is that your view about how slowly this process is working at the moment?
I'm not sure about that, Dace, but certainly if it continues at the current rate, it's multiple years, 2, 3, 4 years.
Right. Okay. Mr. Enright, anything to add to that timescale? Mr. O'Rourke, anything to... Would you share that
I do know that I have heard that there are more panels, the panel is sitting on more days, and so we may see that speed up. But I can't see it. It's going to take a long time, if not years, to resolve the panel decisions. And so my view is, let's just get on with it in the appeal scheme.
So the process at the moment is running so slowly, your judgment is it will still take a matter of years to clear the outstanding cases?
Correct.
Okay. Mr. Aldrich, do you want to just finish us up?
Yep. So the government agreed with Sir Wynn's recommendation to implement a redress scheme for close family members of sub-postmasters. It's a general question to all of you. In your view, how will this impact family members, and do you have any concerns around the proposed schemes? Kieran, do you want your hand shot up there?
Yeah, I've just shot up because I've got some statistics.
Okay, great, thanks.
So we have had 242 family members make inquiries. The government announcement was that there was would be a family scheme which would only compensate personal injury, and that would be where an individual had contemporaneous medical evidence, GP records, what it might be. Now, the reality is, I think that has moved on because there have been ongoing discussions with the Department for Business and Trade. They have engaged us, and the reality of someone whose husband was convicted taking her child to the GP while she was trying to save the family home from being repossessed, as the main breadwinner had left the house because he was an HMP Wandsworth, is unrealistic that there would be some records in there. So our analysis of our 242 inquiries that we've had from family members is that 99% of them have indicated they have some sort of psychiatric or psychological injury. 83% say they have a physical injury, such as nausea, etc., flare-ups of immune reactions. Only 30% went to a GP at the time. So a huge amount would be excluded if that was to remain the case, and I suggest it's not going to be. I think the government have moved from that. 82% suffered a stigma or reputational loss, and there was 92%, it damaged their relationships, their familial relationships. Impact on education, housing and work was 65% of the family members were impacted by that. And in terms of the other important question the government needs to get right, and I do think it is difficult to either you make the scheme very large and very wide, and there could be a fear of overcompensating people, but the real danger is that you make it so narrow that you undercompensate the real victims, and that's a fine balance that government has to find the answer to. So in terms of who is a family member, because that's an important question, we have, of that cohort of 242, 56% are children, 29% are spouses, stroke partners, 7% are siblings, 5% are parents, ex-partners are 2%, and then we have 1% niece, nephew. My concern here is that in South Asian communities, you have a large family group, which is extended family, which became where the family members were involved in the family business of the post office. Yeah. And if we go down the road of excluding, say, brothers, siblings, 7%, then we're in real danger. My other concern is in relation to financial losses, pecuniary losses. We found that in our examination of our client cohort that, or those who would be wanting to make an application under this new scheme, that 49% had lent money to the postmaster to fund the shortfalls. 40% had borrowed money in order to lend money to the postmaster to fund shortfalls. And I don't think these schemes or the proposals that we've been in discussions with the government on are going to easily compensate that cohort. And I think that's wrong. For example, a parent who remortgaged the house to save their child from going to prison, the idea that they should just take that loss and not the public purse, there's something wrong in that as a sense.
Anything to add, Mr. Hodgson, on the definition of the family groups that
I have very similar experiences. I'm privileged enough to look after the lost chances, the children's group. Rebecca and Katie are here today. I'm encouraged by DBT's approach on the new capture scheme, which is light touch and is producing offers very, very early. I think there's some lessons that have been learned. It's important that the cohort of claimants are properly captured so that the genuine victims are compensated. I think we need to be very, very careful that we don't continue re-traumatising people that are so hugely traumatised. Your next witness from Fujitsu is a gentleman who met Lost Chances in August 2024 to hear their story. It's one of the most traumatising meetings I've ever been to. Nine grown-up children that had to grow up too early, age 13, running a job to provide a family income. Another one working in news agents, delivering papers with their parents on the front pages as criminals. Yeah. You know, and this whole experience is deeply traumatising. So when they meet someone in August of 24 that gives them assurances that something's going to happen and nothing happens, those are the things that we need to avoid and we need to take cognizance of.
Okay, well look, the clock is slightly against us, so thank you very much indeed for that comprehensive set of evidence. That's given us a great basis for the recommendations that we make in our follow-up report to this. This concludes this panel. Order. Order. Welcome to this third panel in today's hearings of the Business and Trade Committee as we pursue our inquiries into how do we secure justice for the sub-postmasters. Mr. Patterson, thank you very much indeed for returning to come before the committee once again. We first met almost 2 years ago, and 2 years ago you told the committee that Fujitsu has a moral obligation to contribute to the redress payments for sub-postmasters. The bill provided by the Chancellor is now 1.8 billion. We know that 1.4 billion has been paid out. How much of this will Fujitsu contribute to?
Chair, when we last spoke, I agreed with you actually on the moral contribution topic, and I have maintained that position for the last 2 years since I saw you. In terms of the quantum, the number, yet to be decided. We need to be informed by Sir Wynn's report. Even in the last 18 months of that report, new evidence, new information comes to light. And we want to see that report, and that was in my conversations also with the ministers about our commitment to redress. So we will make a commitment to it. The quantum we will decide when we get to the final report.
So I don't think we know whether Sir Wyn Williams is actually going to opine on what fraction of the bill should be paid by the government and the taxpayer and what fraction should be paid by anybody else. But what we do know is that Fujitsu played a part in this appalling miscarriage of justice because you said, in your words, we were involved from the very start, we did have bugs and errors in the system, and we did help the Post Office in their prosecutions of the sub-postmasters. So let me ask the question in a different way. in your accounts, in your conversations with Fujitsu headquarters in Japan, how much have you provisioned to pay into the redress pot?
This was the same question you asked me 2 years ago about where are we inputting a provision into our report and accounts, and the answer to that is we have not made a provision into our report and accounts. It would be inappropriate for us to do that yet. We have got a commitment. I have made that commitment every time for the last 2 years, and we will contribute to redress when we have opined, or when the winners opinioned on what that quantum should be.
You're a publicly listed company. Surely your shareholders would expect a provision which will be, if not 1.8 billion, then in the hundreds of millions of pounds. How come you've not provisioned to make that payment now?
Because we don't know the exact number of what that should be, Chair.
But why wouldn't we provision 1.8 billion?
Because that would be inappropriate for us to commit to a 1.8 billion.
Well, look, you said when we last met that you had a gut feel, that was your phrase, that staff in your organisation knew there were problems with the Horizon system before 2010. And we now know from your own statements to the Wynne-Williams inquiry and in the contract that was disclosed dating back to August 2006, that was 4 months before Lee Castleton's trial, Fujitsu and the Post Office not only knew that there were problems, you had a contract to deal with them under which Fujitsu would fix Horizon defects and bear liability for losses caused by system errors. We then had the testimony of Richard Roll, who said that Fujitsu employees had been accessing the Horizon system to fix problems. He dates that to his time working with Fujitsu, which was 2001 to 2004. And at that point, there were a reported 30 people working on the issue of wrong payments. So you must accept that there's now irrefutable evidence that Fujitsu knew about these system errors and were managing these system errors well before 2010.
The document I think you're referring to is a reconciliation service description that was disclosed in my second and fourth corporate statement. It was also reviewed by Justice Fraser in his general GLO inquiry as well. I have always maintained, the company has always maintained since I've been sitting in this seat, that there were bugs and errors and there was remote access. In fact, in that document, I agree with you, section 17 talks about remote access. So there was no secret about whether there was or not remote access. The key to that document is how do you deal with the problems. Whether those problems were disclosed to the sub-postmasters in their defence, I do not know. And that was one of your other questions last time around disclosure. I don't know, but I'm certainly not going to deny there were bugs, there were errors. There continues to be. Horizon is a end-of-life product many, many years ago, and you'll also recall the last time I spoke to you, I did not want to renew any or extend any contracts with the Post Office.
But the point is, the new evidence that has come into the public domain and which is now widely circulated in the media confirms that it's not merely a case of having a gut feel that Fujitsu employees knew about remote access. We've now got irrefutable evidence that Fujitsu did know about remote access and the ability for Fujitsu employees to change balances remotely.
Chair, it's never been in doubt from the very start of this procurement back in 1999, and you'll see it in the evidence that's been given to Sir Wynne's inquiry, there were bugs, there were errors. There would always be in any project of this scale, particularly developed in 1990 to 2000. So there were always going to be those problems. The question is, what do you do about those problems? That document that we're both referring to is about how do you deal with those problems. We are not saying there were no problems. There were absolutely problems in the system, and I've been consistent in that position since I've given evidence both here and to Sir Wynne.
If you're then admitting a level of culpability of Fujitsu systems in creating this scandal, then you're accepting that there is a moral responsibility for Fujitsu to contribute to the redress bill, but you're telling us that there is zero provision, literally zero provision by Fujitsu for a financial contribution. That just seems an extraordinary bit of forward planning by Fujitsu.
Well, I don't agree on bad forward planning. We have been consistent in the message and in the commitment to redress.
You're saying that you definitely need to contribute some money, but you're provisioning literally zero in your accounts for that contribution. Please.
So I've answered the question the last time I was here, and I'll answer it again today. We have not made any provision, and we will not be making any provision until we've seen the report. But our commitment to, our commitment, and it has been discussed and been speculated, our commitment is 100%. We will make a contribution to redress to the government when we've seen the report. We've been very consistent in that. Whether we've accounted for it in our report and accounts or not is not material at this point. The commitment is there.
I want to just tell the committee, in the last annual reports that Fujitsu reported, what was the annual profits made by Fujitsu?
So FSL made £15 million last year.
And Fujitsu globally?
That number I don't have in the top of my head.
It's 1.2 to 1.3 billion pounds, depending on the exchange rate. That is about £3.5 million a day. Do you want to just tell us how much in revenue from the British taxpayer you've taken in contract extensions since the moratorium of May 2024?
So when I appeared here the last time and in my letters to the Cabinet Office, I made a commitment that we would not bid for new government business. And we have not bid for new government business. We have got a number of contractual obligations to departments here in the UK, which we are very, very serious about. They are also critical national infrastructure. Government has the right in all the contracts, not just with Fujitsu, with everybody else, to extend those contracts. The government has chosen to extend some of those contracts. The approximate number is about £500 million, which is the total contract value if they go to term.
That's over £1 million a day, basically, since May 2024. So we've got a global group making £3.5 million in profit a day. We've got Fujitsu here in the UK taking £1 million a day from British taxpayers, but there is zero provision for you to contribute to the redress bill of £1.8 billion.
You've heard my commitment, and that commitment's been consistent.
So when you came here 2 years ago, you told us that, in your words, we are an ethical company, quite different to the company in the early 2000s. But you've told us that the company is culpable in causing this scandal. You've told us there's £3.5 million in profits a day, £1 million in contracts from the British taxpayer a day, but zero commitment on a contribution towards the redress bill. You can see why we just can't believe the company has changed.
Well, what's in the accounts and what we provision are, I think, immaterial as to our commitment as a company. What we have done in the last 2 years is we have changed our management, in the last 4 years, we have changed our management team here in the UK. We've run an external organisation called Ethisphere to help us with culture and ethics. We've used that company to help guide us in both our policies, our procedures and our training, not PowerPoint, actual real work in trying to determine whether we are adhering to our own Fujitsu way, which again was one of your questions the last time we appeared. Those things have changed. The company in 1999 to 2005 or 2010 is a very different company today to that company years ago. Whether we've provisioned the sum of money or not, Chair, I do not think is important. What I do think is important, I really don't think it is. The commitment is there from us that we will contribute.
But, Mr. Patterson, right now, we don't know whether that is going to be $1 million or 1.8 billion. You're trying to present Fujitsu as a changed and ethical company. There doesn't appear to be a problem with cash flow. There doesn't appear to be a problem with profitability. There is definitely culpability. But your refusal to tell us how much Fujitsu will pay into a £1.8 billion bill for taxpayers leads people to the conclusion that, frankly, Fujitsu is behaving like a parasite on the British state without an obligation to step up to its obligations.
We're not a parasite, Chair. The government has got an option as to whether they wish to extend those contracts or not. If you wish us to walk away from those contracts, we'll walk away from those contracts. I think that would be detrimental to society. I think it would be detrimental to the UK government. The government and the Post Office have asked us to extend the Post Office contract. We don't want to do that. We're doing it because the government have asked us to do it. So we're not parasites at all. We've been in this country, trading in this country for 40 plus years. Our company is proud of our investments as a Japanese investor in the UK, the 5,000 people that we employ, and the hundreds of subcontractors that we use in this country. We're a very serious organisation about what we do. However, we need to be informed by Sir Win. Even in the last 2 years since I last appeared with you, I didn't know about a capture system. I didn't know before the Horizon system was a capture system. I didn't know that there were victims of that. I didn't know there was legal advice in 2013 telling the Post Office what to do or not to do. That is why Sir Win's advice is really, really important to us, and will inform the commitment I'm giving you again today, and I've given to the committee before, that we will contribute to redress.
How much have ministers asked you for?
Excuse me?
How much have ministers asked you for?
No money, no number has ever been given to me by a minister.
And no minister has asked you to contribute or to begin provisioning for a particular share of your company's cash flows to pay into the redress bill?
My conversation with government ministers have covered 3 topics, and it's a regular conversation I have with DBT. First one is on where we are with restorative justice programme, which was a volume 1 of Sir Win's report, and where are we in dealing with that action. Second one, where are we on the Post Office and the transition from Fujitsu to their new supplier. And the third one, where are we on compensation or contribution to compensation. We have not agreed a number. Again, for exactly the same reason, we don't know the answer yet from Sir Win.
When do you expect that answer to come from Sir Win? When do you expect the answer to come from Sir Win?
I have no knowledge.
Mr. Maynard.
Yeah, thank you, Mr. Patterson, for being here today. Not a difficult position to be in. I take the point about Win Williams and deferring to that, and I think that's reasonable. I think the chair's point about the scale of Fujitsu, I mean, it's £49 billion of market cap. This company can afford to pay a very substantial chunk of, and this whole problem would not have happened without Fujitsu's failures. That's obvious. There are many failures here, but Fujitsu's technology is the root cause of that. I would maybe, with the chair's permission, ask you to send a message back to the chairman Furuta and the CEO Tokita that we look to them personally to take responsibility. It's great having you here, thank you, but we are looking to them to take responsibility for what their company have done to all these people. And when they coming to that redress, we would like them to be here, please, to be in front of us, alongside you and the committee, to explain if they're not paying 1.8 billion in full, why not?
Thank you. I understand your question. The previous Secretary of State for Department of Business and Trade met Tokita-san in Tokyo several months ago. He made the same commitment I've just given to the chair in terms of our contribution to redress and to await the outcome of Sir Win's inquiry. So that commitment was made in the room at that point in time. I can't speak to whether they would be in the room with us, of course, Mr. Maynard, but I can certainly commit to that commitment because I was in the room when the conversation was had. In terms of the core problem here and why this miscarriage of justice occurred, the reason why Sir Win has taken as long as he's taking to investigate is it's super complex. It was over 2 decades ago. Any system of any type, particularly one designed in the decades previous, will have had problems and errors and bugs and remote access. What was done, what was disclosed, what was given to sub-postmasters as an evidence, I do not know. But what I do know is those problems were there.
Thank you. Let's get quickly to that settlement as quick as we can.
Okay, Mr. Cooper.
Thank you, Chairman. Just on that, the situation with the money, you talk about the ethics around it and you say that you're committed to paying something. Why not make an interim payment then? Why wouldn't you demonstrate your new ethical approach and make an interim payment? Are you waiting for Sir Win to give you a specific figure?
I believe if we started talking about an interim number, it would create a whole bunch of questions which would be unnecessary in a vacuum with regards to Sir Win. Secondly, the police are currently investigating 54 people. They've investigated 4 people under caution. All of those things are in play. For me to start talking about an interim payment would be inappropriate in that context. The company is not walking away from the UK. We are here. We've been here for 40 years. We intend to be here for the next. and our commitment to making that contribution is there. But an interim payment would be inappropriate in my view.
Thank you. And you touched on Sir Wynn's recommendation that you embark on a process of restorative justice with the victims. What steps have you taken to action that thus far?
So Sir Wynn published his Volume 1 report, I think, in the summer last year. He asked for a response from Fujitsu, DBT and the Post Office by October. Between all three parties, Mr. Cooper, we came very quickly to a conclusion that, frankly, we needed some experts on restorative justice. In my evidence to the inquiry, I did not understand personally restorative justice. I have been personally educated by the CEO of the Restorative Justice Council, who all three organisations have contracted with. That has produced a report which went into Sir Wynn. We are jointly funding a outreach programme to sub-postmasters, a listening service and a helpline service as well. At the end of this month, there will be a subsequent report from the Restorative Justice Council on what do we do after March, which is where our current engagement between all three parties finish. My expectations and my commitment, and I've made this also into Jim Simon, the CEO, is we expect this to be a 5-year engagement around restorative justice. We expect that, certainly from a Fujitsu perspective, to be focused on health and well-being and education. We think those would be the two areas where we can probably make the most impact.
Okay, so that process has begun.
It has
indeed.
That
5 year is underway. We've heard evidence today that you met with the Lost Chances group who are here in the public gallery. Can you tell us what steps you are taking to support that group? And my understanding of that group is that they work with families affected by all of this. What are you doing to support them?
So the education, I made a reference a moment ago to Restorative Justice Council. Some very clear advice from their 25 years of experience around this is ad hoc meetings with no structure are actually detrimental. And they have guided us and DBT and Post Office around ensuring that any interactions regarding restorative justice, which I think is what is appropriate for the Lost Chances families, is the right vehicle to use. So I'm expecting, and in fact I believe the Lost Chances have been in contact with the CEO of RJC around their engagement in that process. I think 150 sub-postmasters have engaged in the process and have asked for subsequent restorative justice meetings, and we are training Fujitsu people, DBT people and Post Office people to be able to engage appropriately in that process. RJC, though, are very clear these have to be managed appropriately. They cannot just be ad hoc meetings, they can be detrimental.
Your involvement with Lost Chances is through RGC rather than directly.
That would be right.
But you have had a meeting with Lost Chances previously, is that right?
I did meet Lost Chances, and I think Mr. Hudgels made a comment about that earlier. His description of it, I would agree with. It was a very difficult meeting for the families to talk to me about their experiences, which I think I've said before actually. As a citizen of this country, I found it very difficult to listen to, and the impact on them and their families as children. I had hoped we would have been able to do something around mental health and support for them. That turned out that we couldn't make that happen, but I'm now hopeful that the RJC process and the very direction from Sir Wynn will give us a vehicle to be able to engage with them through that process.
Thank you, Chair.
Thank you, Sarah Edwards.
Thank you, Chair. I just wanted to come back to what you were mentioning earlier about ethics and about the journey that you were saying that Fujitsu is currently going through in the UK, surrounding what has been probably what we might call a deficit of ethics in the scandal that obviously we're discussing. Now, of course, the accounting profession has a set of standards and principles and to be chartered, and you have to live up to those sort of governance requirements, but so too do engineers. And of course, there would have been a lot of engineers and information IT engineers working on this software. I think there was around 30 people that were working on this that were mentioned that could access things remotely. And I'm just interested in whether or not you have been engaging with institutions such as the UK Engineering Council, who have a directive from the Privy Council to look at these types of standards, and underneath them you have the British Computer Society, the Institute of Engineering and Technology, who have the delegated authority to look at the chartership. And with that, those who are chartered have to comply with the Statement of Ethical Principles. So I was just wondering, in this advice that you're receiving, or this ethical transition, what are you doing to look at whether or not both the executives that are making the decisions, but also the workforce in its entirety, and whether or not they hold chartership, are going to be adhering to those responsibilities?
Thank you. So the first thing I would say is what we were doing for the Post Office in the 1990s, 2000s, we do not do anymore. So the types of activity that are described, particularly in the document that the Chair was talking about, we do not do that type of work anymore. And in fact, for our current customers, where there is remote access, if I just go back to the essence of your question, the standards and the behaviours and the quality required are both documented in our contracts with customers, and as part of our training, to your point with Ethisphere, it wasn't just a PowerPoint activity. It was a reset. What are people doing day to day? Do they feel they can talk about, I feel uncomfortable about doing something, I've been asked to do something? More than just a whistleblower type of process. How do we make sure that opportunity for people, if they see something going on that makes them feel uncomfortable, can they engage in a way that protects them? We've worked that training through with Ethisphere. When we did it first, our scores were in the low 70s. Their international benchmark is 85. We were 83.5 when we did our last check, which was in October. I think your point, though, about the training with the Engineering Society, I hadn't thought about that one. Forgive me. I will take that one away and check on my side on that topic. Thank you.
Okay. Thank you. Mr. Madders.
Thank you. I'm just going to ask you about government contracts in a second, but I just wanted to come back to this question about provision for some payment by Fujitsu, because I think it's fair to say that we're all a little bit incredulous that there appears to be no provision made for this at all. What conversations have you had with your auditors about how this should be treated?
I talk to our auditors every quarter. I'll be talking to our auditors on Friday. Until there is a definitive quantum that we can quantify, we will not be making a provision in our report and accounts.
Does that mean that you've spoken to your auditors about this, or you haven't?
I meet our auditors every quarter. We talk about all the things you'd expect me to do in talking to my auditors about our report and accounts and our general business, and I have talked specifically about this topic.
And they've advised that it's not necessary to make a provision in the accounts?
Correct.
Okay, that's fine. So I'll just move on then to the question of new contracts, because you've made statements about not bidding for new government contracts. I think it's probably helpful just to go through the detail of that, because I would suggest it's not quite as clear-cut as some of the statements that have been made. In particular, I'm looking at the letter that Fujitsu sent to the Cabinet Office on the 6th of February 2024, which sets out the criteria you apply. So there's sort of effectively three sort of caveats to this not bidding for new contracts, where there's an extension of existing contracts for Fujitsu goods and services. I think we'll leave that one there for now for the sake of time. But you also intend to, it says here, submit bids in respect of re-procurement exercises, or what I would describe as new contracts, by existing government customers for similar goods and services where Fujitsu is the incumbent. So why is that not considered new government business?
Because it wasn't considered new government business by me when I wrote that letter. And I think the only example, which example would you use that we've re-procured?
Well, if it's a new contract issued by government, is that not a new? Because you've got no guarantees that you would get the contract, would you? So that would be new business, surely.
So I determined back in January that wouldn't be the clause. I was very clear about it, and I was clear to the chair, and I've been clear in my letter. If the example you're using is the TSS contract, which is the trader support contract in Northern Ireland, which was procured courtesy of the Brexit process in 2019, government came to tender for that service. We built that service with our consortium on time, on budget, and have delivered it for 5 years. Government came back out to re-procure that, exactly to the point you're making, Mr. Manners. We decided to bid for that. We failed. Government have chosen a third-party company to do it, and our contract will end in November this year.
Have there been any circumstances when contracts have come up for re-tendering within this description where you've decided not to bid?
I would not. We have not bid for 46 tenders that were in the market from government. I would need to check whether any of the extensions we've done are in that. I don't know off the top of my head.
So within that 46, probably some of them would come within this third category of where there's a requirement for new goods and services not currently provided by Fujitsu with its existing customers. Fujitsu would very carefully assess the existing customers' requirements and need for Fujitsu's skills and capabilities. So you're effectively judging yourself whether you should bid for new work there, aren't you?
So first of all, we've not bid for anything in that category, just to be clear. The rationale for when I wrote the letter was we do work for the Ministry of Defence, both here in the UK and internationally, where we have a particular set of skills and capabilities and security clearance. That was the reason for that particular third bullet point.
Okay. But in terms of completely new business, you're confident. But do you know the approximate value of the sort of re-procurement exercises that you've
not the re-procurement, the extensions, is to my answer to the chair a moment ago. I think it is £500 million there or thereabouts, Chair.
Okay. And given that you have already indicated you wish to make a contribution towards the costs of this, has there been any discussion about payment terms being altered in any way as a result, to take account of an advance payment, for example?
No, not at all. Not at all. No, we will. You use the word "we may." I'm being very clear. We will contribute, and there won't be any of those things that you just alluded to. We'll make a contribution, and that will be that.
Okay, thank you.
Okay, thank you. Just a couple of questions to round out. So, when you bid for government contracts, you've been asked to demonstrate some contingent liability insurance. To what extent do you think Fujitsu's liability insurance will cover off the redress payment that you may have to make in due course?
Don't understand the question, Chair. Forgive me.
Well, very often when you're asked to procure for public contracts, you've got to demonstrate some kind of insurance for the service that you're providing in case, for example, you make errors that cost the customer money. Mm-hmm. You will have insurance in place to underpin many of the public contracts that you've bid for. Mm-hmm. When you make that redress payment to the taxpayer, how much of that redress payment do you expect to be able to claim back from your insurance?
So I'm not sure I'm going to be able to answer your question entirely. So in our current contracts that we have with government, in some of those contracts there is a parental company guarantee, a PCG that is a self-insured process from our parent either in Europe or globally. I wouldn't be able to comment in detail on our insurance cover. I would need to check that, Chair, and I can, like I did the last time, I'll drop you a note on that.
Thank you. And then on lost chances, do you think at the moment that you are contributing the right level of resource, either financial or anything else, to the lost chances group?
So my answer earlier, our focus is, as directed by Sir Win, is on the restorative justice process, which is, and I think government are engaging with the Postal Museum on one part of legacy. I've made the comment a moment ago, we expect our contribution to be for possibly up to 5 years, and that will be in the health and well-being area and education area. The families, and as I mentioned, should be coming through the restorative justice process rather than direct conversation with us. We will be focusing all of our attention on restorative justice.
But you're satisfied that Fujitsu is making the right level of contribution to that process?
So everything that RJC have asked us for on our side of the table, we have committed to do. I've made the commitment both in writing and to Sir Win that we'll also continue that for the next 5 years. The next part of their report is at the end of this month, which will tell us what we're going to be doing afterwards. Okay, so I don't expect any issues, Chair, with our commitment. We are fully committed to it.
Okay, thank you. Well, it feels to us on the committee that Parliament has done its bit, overturning convictions. The taxpayer has done their bit, contributing 1.8 billion to the redress scheme. It feels to us that we're still waiting for Fujitsu to do its bit. So we look forward to continuing this dialogue with you as Sir Win Williams finalises his report and we finalise our recommendations. But for now, that concludes this panel, with our thanks to you for coming before us to give evidence. Order, order. Order, order. Welcome to this next panel in the Business and Trade Committee's hearings into securing justice for the sub-postmasters. Nigel Relton, Joanne Hanley, thank you very much indeed for coming before us. Charlie Maynard is going to open the questions.
Thank you, Mr. Relton. So I've got your letter here from 18th of December from the Post Office talking about redress update, and that's helpful, so thank you for that. We've also had the panel earlier talking through the HSS panel and that process and the time taken to do that, and then kind of flipping into the HSS appeal process where often the payouts are multiples higher. And I guess, you know, in your letter you write about full and fair redress, and this is a joint statement, DBT and Post Office, but as I might not be right on this, but the HSS panel is administered by the Post Office and comes in with offers this high, and then the HSSA panel is administered by the DBT, which comes in multiples higher. And yet you're both saying it's full and fair redress, and the HSS panel, at least based on the information we're getting, is takes time. The postmasters don't have access to proper legal advice. They don't have access to forensic reports. How is this helping anybody?
Well, I found the sessions earlier incredibly interesting and helpful, actually. When I came to this committee, November 24, I made it very clear that I did not think the Post Office should be administering these schemes.
Is that still your view?
Yes, absolutely. However, at the time, we said we had to be pragmatic, and the Post Office would continue to process the HSS schemes. But what we were really talking about in those terms were the 75,000 fixed sum offers, where it was an administrative task rather than something that needed judgment. Now, I'll ask Joe to talk about the other schemes in a moment, but in terms of the HSS £75,000 schemes, where we do purely administer, we've made great progress over the last year. So, for example, in 24, we processed 1,000 claims. In 25, it was 8,000. And the number of claims outstanding has gone from 55% at the end of 24 to 18% at the end of 25 as we get to the closure date. Now, I think what I'm hearing this afternoon, is that the complicated cases are not for the Post Office, because We worked to a formula.
They're not moving at all. I mean,
Well,
there's been 40 done since January.
Well, we worked to a formula, and we don't have any say really on how that formula changes. So, Joe, do you want to add to that in terms of how you deal with it practically on a day-to-day basis, please?
Yeah, absolutely. I think there's a piece here around some of the pieces that we've spoken about in terms of the benefit of upfront legal advice, because I think actually if claimants did have upfront legal advice, that would really help a lot with actually getting a claim that is first off is actually clearly articulated. I think that is part of the challenge that sits with HSS before you get to the appeals process, is that claimants are doing that a little bit on their own. What we have looked to put in place from a post office point of view is set up a claimant support team, which we did at the middle of last year, with nominated single points of contacts to support postmasters through that process as much as we possibly can. And I think that has started to help some of the piece there, but I think the legal advice piece is actually a critical factor, and that makes a big difference between the initial claim and then the claims that ultimately do go through the appeals process. I think there's a key factor there that it does help claimants.
So, I mean, we feel like we're locked in a system which nobody thinks is much good, and you know that there are consequences to that. You know, very very real human consequences to it. So, if we all acknowledge that this isn't working very well, and we can ask the minister very shortly, but you know, what's needed to fix this? I mean, are you telling us that if the post office doesn't think it's the appropriate person to be handling those HSS panels? What would you recommend here? That we kind of shortcut the process, go to HSS-A type information, ask for forensic reports, get proper legal advice with each of these parties and get them done quickly? Or is there any kind of ranking or tiering in terms of this lot that way, this lot that way? What do you recommend?
I think my suggestion breaks into two different areas. My suggestion is we've got the closure date now on the HSS fixed sum offers, the end of January. Joe and the team have done a great job in kind of working through those. So post-January, we'll work through the tail end of that, and at that point, anything that's admin in nature will have dealt with. And I think at that point, this should all move to DBT and be dealt with under one organisation and one department that has, you know, the decision-making authority.
In February?
Pardon me?
In February?
That's probably too soon, but probably March, April time, I think, which is what I said, Chair, last time. But I think, you know, we have been pragmatic, we have worked through it, but, you know, I think what will happen over time now is the number of cases will reduce, not as fast as any of us would want, but I think at DBT will then be dealing with a smaller cohort, but of those things that are more complicated. And, you know, it's not right that Post Office are dealing with anything complicated, that anything's got any decision-making to it. It just isn't right.
Could I just come in here and just add a couple of points as well? So, you know, I think if we look at the January closure date, that of course is for all the Horizon shortfall schemes, so that's both the fully assessed and the FSO. I think, you know, to Nigel's point, there's a huge amount of progress that we have made in terms of the simple claims to date, and actually 80% of the outstanding claims that stand there today are for the fixed sum offer rather than the complex fully assessed scheme. So I think, you know, there's a huge amount of progress that's been made there. We do expect, because we are continuing with ahead of the application closure deadline, we are receiving quite significant volumes of new applications, and so pre-Christmas that was averaging around 250 new applications a week, primarily in the fixed sum offer space. So we do expect to have worked through all of those by the majority of those by the summer period. As it stands at the moment, the fully assessed claims...
Summer 26?
Yes.
Yeah.
As it stands at the moment for the fully assessed claims, so whilst actually it does look as though they are still taking a number of years, we are receiving new applications still in the fully assessed scheme, about kind of 10% at the moment from, if we look at the tail end of last year, is what we're receiving.
That's what, 25 a week?
Yes.
Yeah.
And I think if we just play that piece through, we are seeing that with the newer claims, we are looking more at a 12-month turnaround time than we are the couple of years that it has taken previously. So things have sped up. They're not as quick as we would like them to be, and not necessarily as quick as the DBT scheme, but certainly there has been an increase in pace for new claims that are coming in.
Just running with that. So if the January, end of January date stands, what would you recommend with somebody who comes in late after that? They go straight to DBT?
I think so. I think we're going to give people a couple of weeks leeway for the deadline's obviously a hard date.
I mean, obviously we need a plan because, I mean, just kind of saying tough luck here, given the trauma and everything else, is probably not. So it would be good to have a clear plan as to what happens if you're saying that's closing at the end of January. What happens to anybody who comes in late?
For the end of January piece, we are absolutely working in conjunction with DBT on exception criteria in terms of what that will look like. I completely agree with you that when we think about the vulnerability of the claimant population, we need to make sure that there are certain criteria there in order to be able to support any late applications, and that's something that we're working through along with the department.
Of course, the closure date was a recommendation of Mr. Wynn's, and he suggested the end of November, I think it was, and we thought that wasn't appropriate because of Christmas. So we extended it to the end of January, and as you say, we are looking at exceptions and how we deal with them for those people that can't meet that deadline date.
Okay, Sarah Edwards.
Thank you very much, Chair. And just sort of moving on the basis of the speed, in particular, of the payment. So I think as of sort of November last year, 87% of all of the HSS cases had received an offer, and 84% of late claims, and 100% of original HSS cases had actually, been received an offer. So given that we've still got a number of people who still have not had that, when do you think they will have an offer or you will finalise those payments through the scheme?
Do you want to answer that, Jo?
Yes, absolutely. So
Please.
that's a little bit in terms of the data that I shared earlier. So what we're looking at for certainly when we think about the around 2,500 applications that we had at the end of the year, as I say, that is increasing when we think about the until the ahead of the closure date. We are continuing to receive applications at a quite high rate. But say our current operational forecasts are that based on current volumes and the current backlog, that we would look to have those complete from a fixed sum offer point of view by the summer, and from a fully assessed point of view by the end of this year.
I think what it also demonstrates, though, is that the things within our control and things outside of our control. So where we have complete control over the 75,000 fixed sum offer, as I mentioned earlier, we've gone from 1,000 in 2024 to 8,000 in 2025. That we can control. But the things outside of our control, where it requires judgment, and we've heard some stories today of amounts increasing significantly and going to appeal or into different schemes, and I think that being under kind of DBT and one organisation and one department, I think would make sense.
Thank you. And then at this stage, do you think that administration should still sit with the post office? Because there are a lot of sub-postmasters who don't think that you should be administering the redress scheme at all. And obviously there have been some discussions about whether or not that gets transferred to DBT. So do you think that should transfer, or are you happy that it sits with you?
I think I made my position clear last year and it remains the same. But pragmatism is the order of the day. We are less than a month away now from the closure date for the HSS scheme. So we should work to that date. We should do everything we can. We don't want to disrupt things, make things worse. But post that date, I think that's a real milestone where we think about what happens next. And my position is that it should move to DBT.
Thank you.
Has DBT got enough resource deployed in its caseworking teams to make decisions fast enough?
Don't know, Chair. I think it's probably a question for DBT. And
what's your perspective?
I don't know. What do you think, Jo?
So, I mean, from what we've seen to date, I mean, we are not as close to the data on that side in reality as we are from a post office perspective. So I wouldn't be able to comment.
Well, I will say, though, that DBT, we do work really well with them. They're very supportive of things we're trying to do. This is, again, probably down to a system and process issue rather than any individuals.
Yeah. We've heard some pretty traumatising evidence from our witnesses at the top of today's session about the inadequacies of information sharing arrangements when it comes to the the overturned conviction scheme. Do you have a view about why the Ministry of Justice is finding it so difficult to patch together the right information to make good decisions?
I was shocked when I heard that, because my understanding and everything I'm told as chair is that we provide all information that's required of us. We are fully transparent. Anything anybody wants to any information from us, we provide it. So it's really about, is it the quality of the data that is a problem? And I don't know the answer to that, because many of these cases are going back many, many years, and I suspect it's probably a quality issue, but I think I need to go back and look at that.
What do you think now needs to happen to de-risk this decision-making process in the MOJ, given what you've heard today?
I think that there needs to be a policy decision, because if, absent decent data, which I imagine if you're going back 20 years, the data won't be very good, if at all. And I think we are lucky because we do have some of the data. Then I think somebody again has to make a pragmatic decision.
But what can you do as chair to cross-check whether the post office is supplying data at the right level of integrity into MOJ?
Well, I'm going to go away and do that.
Okay.
Having heard this today, definitely go away and ask that.
Thank you. Antonia Bance.
Thank you very much, Chair. I'm turning now to the capture software. And I'd like to ask, what information have you shared with the Criminal Cases Review Commission relating to capture? Are you still reviewing your records? And if so, how much longer will it take before the CCRC has all of the information that it needs?
Well, of course, this, again, scheme has been administered by DBT, and we are providing information as required. And again, we provide everything we can. This is really hard as well, because it's going back to 1992, where some of the records are, not digital, these are paper records, so going back, but we are doing everything we can to provide all the information that we have, is what I can say to you. And do you want to answer that, Jo?
I think you're absolutely spot on, Nigel. So, but some of the challenges here are due to the what data actually is available, and that is absolutely a challenge. But also kind of looking at paper records, as you say, which is not as easy as it would be as if we were looking at it from a digital point of view. But the commitment is absolutely there to provide and make sure that we do, as a unit, provide the information that's requested and required.
What sort of timescale have you put upon that?
So there are individual disclosure pieces that we're working on. We're working on a number of initial cases from a pilot scheme point of view with DBT, and we've got a plan to do that over the coming months.
Okay, so you're working reactively as requests are made of you. Are you also working proactively to anticipate future requests?
So it's something that we're working together along with the DBT on. So we absolutely do have a plan going forward. It's just that we've looked at a pilot first off in order to be able to really understand what data can be found, what challenges we're encountering, and how long it actually takes to be able to do that, so that we can work on a true plan going forwards with the department, so that we've got that for all the cases that we need.
Okay, thank you. I'm sure we will ask you more about this in the future once you've completed that pilot. And then finally from me, obviously the Horizon-related convictions were overturned by legislation, by Act of Parliament. Do you think that the government should legislate to overturn capture-related convictions? Nigel?
My opinion, yes.
Okay. Thank you.
Very clear. Okay. Just very quickly, give us a sense of the process here when it comes to capture. So do you basically get a phone call from someone at CCRC to say, right, we've got this individual case that's come to our attention, can you now supply us with the following schedule of documents? Are you able to sketch out what the process is?
Let Jo just sketch out the process, please.
Yeah, absolutely. So the capture scheme is managed by the Department for Business and Trade. So we, in effect, provide a service to the department in the administering of that scheme. So hence kind of why the pieces that the plan that we have is working very closely with the department to understand the total cases. So it's really a disclosure of information to DBT is what the Post Office's involvement is in the actual cases.
Okay, so I don't expect you to have this now, but given what we've heard today about some of the delays in the Post Office supplying information, are you able to perhaps give us, by way of follow-up, a sense of how many requests have been made to you, and on average, how long is it taking you to satisfy those information requirements?
Yes, absolutely.
It would also be very helpful if you could supply us with the level of resource that is working on solving this problem, so we can cross-check that as well.
Absolutely.
Okay, thank you. Can I just ask one final question, Mr. Elton? So, on the original deadline for the Horizon Shortfall Scheme, the cases that came in up to March 2021, There's been almost no progress in resolving those cases between January and November last year. About 40 cases have been concluded. So the number, the percentage of cases resolved appears to be pretty stuck on 88%. These are all cases, presumably, that should be just transferred over to DBT to resolve now.
Yes.
Okay.
I believe so.
What do you think is stopping DBT embracing this recommendation of yours? It's obviously a recommendation that this committee has made at least twice now, but the department appears to be resisting it. What's going on there, do you think?
Perhaps resources.
Mm-hmm.
Not enough resources, perhaps not wishing to disrupt the process as it is today. You know, I think there was a lot of moving parts, and to have more and more moving parts was probably why they didn't want to do it a year ago. I have some sympathy for that, but I think as things are becoming clearer, I think not just in terms of the £75,000 deadline being passed, but as in terms of the issues are becoming clearer and the blockers are becoming clearer. And I think, this committee has started to explore those, and we're hearing more of them today. I think the issues are becoming clearer, therefore the blockers are becoming clearer. They have far more ability to remove them than clearly I do.
So we're beyond the point now where the disruption outweighs the advantages.
In my opinion, yes.
Yeah. Joanne, did you want to add to that?
I just wanted to share a little bit and just go around some of the detail there. So I think if we look at the cases that are outstanding today, just to provide a little bit of clarification. So of the kind of 2,500 cases that we've currently got, 80% of those are fixed sum offer. So those are ones that absolutely we expect the Post Office to continue to deliver, and that they will be delivered primarily by the summer period. So at the moment there's about kind of 500, less than 500 cases that are in the fully assessed space that potentially we would look to
just want to make sure that I've understood this though. So when I look at the total claims received, I can see 12,540 claims across all of the schemes. I can see 9,793 claims that have been paid. So 2,747 claims have not been paid. You're saying that you think 80% of those 2,747 are fixed sum offers?
Yes.
And therefore you think most of those will be resolved by the summer?
Correct.
So we are going to have a number of cases, a few hundred cases, that are going to take longer.
Yes, because they'll be on the fully assessed side, yes, and those are intended, if they stay with the Post Office, current operational plans are that those will be substantively completed by the end of the year.
If those cases were indeed just transferred wholesale to the department for resolution, do you think that there is actually a chance, that there is actually a final chance that 2026 could be the year in which all of the redress payments are paid to those who have suffered so much?
I certainly think that for the cases that are currently administered by the Post Office, that is already our intention to actually do that this year, although some, if we continue managing the schemes, are likely to fall into the first part of 2027. So I think if it stays with the Post Office, that is what our current plans show. I think in terms of whether DBT feel that they would be able to do that quicker is probably a question for DBT later.
Okay, Mr. Relton, what do you think? Do you think this actually could be the year where we get this finally done?
I'd like it to be the year that we finally get it done. I think with the, a lot of the overturned conviction schemes now are being settled, so that should free up more resource in DBT. So I think perhaps, the transfer of the more complex HSS schemes to be combined with the team that were dealing with less overturned conviction schemes is probably a good thing. Hearing what I'm hearing today about how long things are taking, I think 2026 sounds optimistic, but I certainly think it should be a goal.
Final question then is that we've heard from a number of lawyers representing victims that there could well be many other people who were convicted who have not yet been contacted by MOJ, even though they may be entitled to have their convictions overturned. How worried are you about that possibility?
I'm not worried about that possibility because it's not within my responsibility, and that's not to shy away from the question. But when I heard the fact that they're not contacting people, I was surprised. I think if people are having convictions overturned and walking away from compensation that they're entitled to, I think that's really concerning. And I'd suggest when you speak to the MOJ, they go away and look at their process and how they deal with that.
Do you think there is a possibility that there are people over and above the 1,000 or so that the MOJ has identified? Do you think there are people over and above that number that could have had a conviction that aren't yet within the consideration?
I really don't know. I don't know. It's clearly a possibility, isn't it? But I don't know.
Right, thank you very much indeed for the new speed and vigour that you have brought to this process of redress for sub-postmasters. That is appreciated by the committee, and as is your candor this afternoon. That concludes this panel. Order, order.
Thank you, Chair.
Order, order. Welcome to the fifth panel in today's hearings on justice for the sub-postmasters. Amanda Pearce, thank you very much indeed for joining us. We're really grateful for you coming along and giving evidence today. As you know, we're more and more concerned about the capture cases. We understand that there are cases, or there is at least one case in the High Court, so we will be careful about the lines of questioning that we give to you today. But at this stage, the first question is really, does the CCRC have a good sense for how many capture-related convictions there may be?
I think the simple answer to that is no. We have 35 pre-Horizon applications, and the reason I refer to them as pre-Horizon applications is because we know that they don't all involve capture. Some involve other computer systems, and in fact we've already referred one case on the basis of concerns about the operation of the automated payments system. We received a list in January last year from DBT of around, I think, about 480 convictions in the 1990s. And that list, as we understand it, was produced by Post Office in response to a request from DBT to try and identify capture cases. At that point in time, there were 31 cases on that list that were identified as potential capture cases. At the same time, we had 28 live cases, only 7 of which were on that list of convictions. So first of all, it's not a complete list. Right. Some of the convictions on the list don't have names. They're post office branches, so post offices, rather than named individuals. Of the 7 cases of ours that were on the list, none were marked as using either capture or any of the other software. But 2 of those 7 cases are ones that we have since referred to the appeal courts, one on the basis that it was a capture case, and one, as I say earlier, on the basis that there were potential problems with the automated payments service as well. So that list is not reliable.
Right. Sarah Edwards.
Thank you, Chair. Maybe a bit of a complicated question given the information that you've just shared. But I guess so. How many applications have you so far had, or do you think you've had, relating to the capture convictions? But actually, we probably need to broaden that and talk about software failure or automated transfer of funds, perhaps, because we're talking about automated payment systems now, which is that a piece of software that is used by the bank, or is that used by the post office?
That's another post office.
Is that widening the scope yet again, potentially?
Yeah,
Could you provide us a bit of information on that?
So we've got, as I say, 35 applications which we have sort of termed pre-Horizon cases.
That's individuals who have applied to you.
That's individuals who have applied to us,
So they've come to you?
Yeah.
Right.
So there are 35 cases. Of those, at the moment, there are 2 where we are certain that capture was used. In the other cases, we are trying to establish whether capture or some other system was in operation. We know that there were a number of IT systems which were in operation prior to Horizon, but there is a real lack of reliable information about these cases because of the age of the cases, because they are around sort of 30 years old. Some of the applications we have got predate the introduction of capture, so they won't be capture cases, but they may be cases where there's other software. And as yet, other than the automated payment service, we don't have information to suggest that those other programs, that other software was flawed. But we are mindful that that's a possibility. That's something that we're looking at. We're also, in these cases, alive to the possibility that, given the basis that we referred the Horizon cases on, which was not just that the software was faulty, but that also that there was a lack of disclosure and a lack of investigation, there are those wider considerations when we're looking at these cases as well. It's not beyond the realms of possibility that there could be a case where there isn't an IT software issue, but there are nevertheless issues around disclosure and investigation. So the consideration, particularly of these pre-Horizon cases, is quite broad.
The failure may not just be an IT failure.
That's a possibility, certainly. But the challenge, as I say, is that because of the age of the cases, there is a real lack of reliable information.
Anything further?
Thank you.
Mr. Madders.
Yeah, I mean, it sounds like when you start looking at one of these, you've literally no idea where it will lead or how long it will take. And I think that's something that we want to try and understand, is if you've got any idea what sort of length of time these investigations are going to take.
It's really quite difficult because they're obviously not a homogenous group. So the oldest of our open cases was received in November 2024. So that one is sort of 13, 14 months old. The most recent application was October 2025. So they're all at different stages, and there are differences in the amount of available information in the cases. So in some cases, Post Office has got information, they've got files, they've been able to locate information. In others, they can't find any information at all. In some cases, applicants have retained papers and they're able to provide some information. There's very little information from the courts. So we have a power under the Criminal Appeal Act to require any information that's in the possession or control of a public body. So we don't just go to Post Office, we go to the court. We try the police if it's a case where there might have been police involvement. We try the applicant if they've got material. But there are a range of inquiries that need to be made in these cases to try and establish what, if any, system was in operation and what part it played in any conviction.
And clearly, sometimes you're just not going to, the information just isn't going to be there anymore. But are there occasions when there is information and it's taking rather longer than it ought to get hold of that?
I think so. There are a number of threads to follow in these cases. I think when we're requesting information from Post Office, they are trying to provide it as quickly as they can. As I say, they can't always find information, and our experience across not just the capture on pre-Horizon cases, but the Horizon cases as well, is that sometimes we're told we don't have anything, or you've got everything, we've given you everything we've got, and then some months later, more information will be found. So we've recently had information on one of the pre-Horizon cases which suggests that in fact Horizon was installed earlier than had originally been thought, and that case may in fact be one that benefits from the Horizon legislation. So it's complex to try and pin down the information in these cases.
Okay. And I mean that's quite interesting that Horizon may have been installed earlier than we thought. Gosh, that probably needs a bit of processing in itself. But in terms of the time this is taking, obviously these convictions were 30 plus years ago in some cases. Are you concerned that actually some of the people involved may pass away before this gets to a conclusion?
We're absolutely aware that these are very old convictions and that the individuals are elderly in some of these cases. So around a third of the applications that we're dealing with are made by families on behalf of people who've already died. There are around a third where the sub-postmaster is over 70, and then a third where they're under 70. So we are conscious that these need to be addressed as a priority. And we are working as quickly as we can to get through them and to get the information that we need to make a decision.
Thank you.
Amanda, realistically, even on those 35 cases, best guess, how long will it take you to work through those?
So the two cases that we've already referred, one took 18 months, one took 2 years. I think that we are moving faster on the cases now. I think what happens, and we found this with the Horizon cases, is that the early cases, there is more work involved in establishing the legal argument and drafting the decision and making the decision to refer. Once we have that framework, that helps with the subsequent cases. So I would hope that the later cases won't take as long, but it is very much about trying to find that available information and trying to make sure we've followed every thread that we need to follow to try and establish what system was in operation and what part it played in any conviction.
But the picture you've painted this afternoon, best will in the world, there's not a hope in hell that we're going to be able to assemble all the information that's needed to make a good judgment.
It is very difficult, yeah, and there will be cases where we simply don't have the information. One of the things that we have done is we've spoken directly to applicants, and sometimes, understandably, with the passage of time, people don't always remember which system they were using, but there are situations in which we can talk about the process that somebody used for managing their post office accounts, and we can infer from that what system they might have been using. And of course, we don't need to be 100% certain. The Commission's test for referring a case is that there's a real possibility of a successful appeal. So we need to get to the stage where we think there is some evidence on the basis of which the court might conclude that this was a case which relied on data from a flawed system and that was essential to the prosecution. So our test for referral is a relatively low bar, but we do need to find some information and some evidence on which we can make those decisions.
Once you've made a referral, what happens then?
So it will depend where the original conviction was. So if the person was convicted at the Magistrates' Court, we would refer the case to the Crown Court, and that would be dealt with as a rehearing. In general, our experience of the Horizon cases is that the appeals weren't opposed and convictions were quashed. If somebody is convicted at the Crown Court, we would refer it to the Court of Appeal, and then it proceeds as an ordinary appeal. So counsel would be instructed, grounds of appeal would be lodged, and it would proceed as an appeal in the ordinary way.
The courts are obviously under terrific pressure at the moment. So what's the best case scenario for how quickly a case would move through the courts once you've referred it?
That's quite a difficult question to answer because it depends on the parties lodging their grounds.
What's your professional judgment?
I think that these cases, the aim will be to deal with these relatively quickly. I think the court will be as aware as the CCRC is of the need to move as quickly as possible on these cases. So the two that we've referred so far to the Court of Appeal, as far as I'm aware, haven't been listed yet, but I would imagine that they will try and move relatively quickly on those cases. I would really be pulling a figure out of the air if I was trying to give you a number of months.
Feel free to pull that figure out of the air because your definition of fairly quickly might be different to mine.
That's true. So don't hold me to it. I would hope that it wouldn't take more than 6 months. Might even be faster than that, but it is very much dependent on the two parties involved.
Look, given the age of these cases, given the known systemic problems with capture, given the time that it will take you to work through the cases, given the time that it will take the courts to work through the cases, given the challenges in assembling the evidence required, is there not a case for Parliament extending the overturned conviction legislation to include capture cases?
So I think the Commission would be in favour of anything that helps to remedy a miscarriage of justice. What I would say in terms of a legislative solution is that we heard earlier today that there are challenges with the Horizon legislation and the application of it, and it's not always the neat and tidy solution that we would hope for.
No, but it has worked for
absolutely a considerable number of people.
111 people.
Yeah, absolutely. But equally, as I mentioned earlier, we've got a case now where we think the person was turned down on the basis that Horizon wasn't installed, but there may now be information to suggest that it was. What I would say in terms of a legislative solution for capture cases is that the drafting of that legislation would need to bear in mind the difficulties that we've experienced in terms of identifying whether capture was in use at the relevant time. And I think it would also need to bear in mind the possibility that there are other flawed systems. So any legislative solution might need to be drafted in very broad terms. Otherwise, we could be back here in 12, 18 months' time talking about a different system and whether further legislation is required. So it's not a simple solution. It's a potential solution, but it's not simple, I think.
Caveat this how you like, but you've got a long and distinguished record in this field. You've seen a lot of things. As a professional servant, professional public servant, in your heart of hearts, do you think there is a case for extending the Horizon legislation? If we've got to be careful in extending it, but is there a case for Parliament to look at extending it?
I think there's certainly a case to look at it, yeah, absolutely.
Amanda, thank you very much indeed. That's all our questions. Thank you very much indeed for coming along and being open with the committee this afternoon. That concludes this panel. Order. Order. Welcome to the sixth and final panel in today's hearings on justice for the sub-postmasters. Ministers, thank you very much indeed for coming along this afternoon. Thank you for your patience sitting through the evidence, and thank you, Christina Pride and Carl Creswell, for coming along to support. Alex, if I may, let me start with you. You'll have been fairly horrified listening to some of the evidence and testimony that we've heard today. Do you want to just give us your quick reactions, and then I'm going to ask you some detailed questions about the data?
Thank you, Chair. Thank you to the committee. Yes, I was present for the last two sessions, but have been following the committee quite closely all day, and the testimony of victims particularly has been harrowing and difficult to hear. Listening to them directly, when we talk about figures and numbers, it's important to remember that these are actual people whose lives have been completely upended and destroyed to some extent as a result of what happened to them. So it is a great miscarriage of justice, and one that this government is seeking to put right.
You're a new minister,
yes,
but the legislation is now almost 2 years in place. So far, 611 people have been identified as having at least one conviction quashed, but only 450 have been paid in full. Why is there such a big gap between those identified as having a conviction quashed and those who have been given a final and full settlement?
So under the scheme regarding the Horizon legislation, quashing the convictions, the Ministry of Justice have, as of October last year, we've identified 1,002 individuals that are eligible and within scope of the legislation. Out of that 1,002, we have written to 574 individuals to inform them that they have at least one conviction that is able to be quashed by the Act. We have written to 152 individuals who do not appear to have a conviction in scope to request further information, and we have written to a further 44 individuals to inform them that they have been confirmed as having no convictions to be able to be quashed by the Act. Out of the 1,002, I think it's also important to alert the committee that we have assessed 1,001 of the cases. So we are at 99.9% completion rate as of October. We are aware of other individuals who are self-identifying and coming forward to the Ministry of Justice, and we are assessing those on an individual case-by-case basis.
Let me just get a sense from you of this. So you've sent 574 letters to individuals telling them their convictions have been quashed, but only 498 claims have been received. What's your feeling for why there is such a big gap between those two numbers?
It's been really, really difficult, as you will have heard, in order to trace individuals, to get them to come forward, even when they're entitled to compensation that is quite rightfully legally theirs, and they are more than entitled to. We have had very difficulty reaching a large number of applicants and claimants, given data discrepancies. We have been using a number of agencies, whether that is HMRC, the Post Office directly, DVLA, the Passport Office, Equifax, looking at any information we can in order to identify them and write to these individuals to try and get them to come forward and get what is rightfully theirs. But it has been a big, big struggle.
When you were preparing for your evidence today, were you satisfied that the department is doing everything necessary to track down the individuals whose convictions have been quashed?
Yes, Chair. The individuals we have working on this are extremely dedicated in the Ministry of Justice. The caseworkers have taken this personally and to heart. We've got a very, very brilliant, dedicated team of individuals who are seeking to right this wrong. The entire country has been captured by this grave miscarriage of justice and want to help, and these individuals working on this in the MOJ are no exception to that, and they have been straining every sinew to try and reach individuals.
And how many people are in those caseworking teams?
So we currently have 8 full-time caseworkers on this, but that's only because we have one case left outstanding, notwithstanding any others that come forward in terms of self-identifying. As of November 2024, there was a much larger team working on this, but currently there are 8 full-time caseworkers, but we are able to scale that up as necessary.
We'll come back to that in a moment. It's been put to us by families of some of the victims that there is an inequity in the way that the full and final offer is presented. So the full and final offer is presented as 600,000, but actually when people embark on this process of seeking redress, 200,000 is paid up front. The question that is put to us is why 600,000 is not paid up front, because it could well be that there are many families who are entitled to far, far more, but are feeling, frankly, under an enormous amount of psychological pressure to accept a much lower sum. So is it not time now, in the light of experience, to review the scheme design and provide for the £600,000 upfront and allow those who are entitled to further redress to prosecute their claims with you?
The compensation is paid from DBT. We are in charge of quashing conviction, so I'll pass that over to my colleague.
So as recommended by Sir Wynne, claimants now have 3 months to revert to that £600,000 offer if they do go down the route of the full assessment. So we're trying to remove that pressure, that feeling of jeopardy that you describe.
So people can accept the 600,000, or rather, can people take a £600,000 cheque up front and continue to prosecute a claim for more?
No, they can't. No.
Okay, but you accept that people may feel that they are entitled to more, but nonetheless.
And if they do feel they're entitled to more, they can get that fully assessed claim. And then they have that 3 months to revert to the £600,000 if they feel that is better for them.
So you're satisfied that that psychological pressure that many victims have reported to us has now been relieved?
And it was, as I say, reported to Sir Wynne, and we've taken on his recommendation on that.
Well, we will check that with them.
Yeah.
The evidence from the Eatons this morning was, frankly, harrowing.
Yes.
And it did, as I described to them, feel like there was a consideration that was in secret, a decision that was made in error, and an appeal that was frankly in the lap of the gods. Now, there were a couple of issues that arise from this for us. So you've said to me in the letter that you sent before Christmas that 29 people had had convictions quashed when at first they were judged not to qualify.
Correct. However, Mrs. Eaton was not included in that figure. She has now been added to it.
I did want to check that,
yes.
But nonetheless, that is an error rate of about 5%. And so the question is, how are you going to make sure that actually there aren't more people who have been wronged in the way that Mrs. Eaton was?
So it's an error rate of around 3% out of the 1,002, so around 30 people.
So it's 29 over 1,002 rather than 611.
It's over 102, yes, that's correct.
Yeah.
So it's out of the 1,002 rate, so it's around 3%.
You'd accept anything north of 0?
Well, I would accept anyone who has had to go through the arduous issue of having to provide more information is one too many, Chair. However, the requirements of the Act, as you will be aware, are quite strict and therefore are quite limiting on us as the Ministry of Justice. And anyone who has felt like their application has been unfairly judged is able to provide more information. And in fact, we ourselves have been seeking, as the Ministry of Justice, to find more information on individual claims as well.
Mrs. Eaton didn't know her claim was judged.
So I'm very, very conscious not to talk about individual claims here.
But I'm talking about a witness that's given us evidence.
Yes, and I'm aware of that. And I did say to the officials that if the case was brought up and if Mrs. Eaton discussed her case, then I would feel obliged to respond. Mrs. Eaton's case is one that is a prime example of how the data has failed us here and how we've had to get more data and more evidence for the case. My understanding is that Mrs. Eaton was told that her case was requiring more information, and if more information was to come forward, then we would reassess. That is what has been done. I'm pleased to say that we have finally ruled Mrs. Eaton in scope of the scheme, and her convictions have been quashed.
So there are two issues that arise from this. So the first issue is, how can we know, and in particular, how do you know, that there aren't more Mrs. Eatons out there? So you've assessed 1,002 people whose cases appear to qualify under the Act.
Yes.
How can you be sure that that number is correct?
So we can only be sure in what evidence we currently have, Chair. So on the basis of the evidence that we have had available to us as the Ministry of Justice, out of that 1,002, 574 of them have been told that they are eligible and within scope. However, those who have been written to and told that they are not in scope haven't been told that that's the end of the story. The scheme remains open. There is no deadline on this. And if more additional data, evidence, information comes to light, then we would encourage that to come forward, and we will reassess applications.
Okay, so the bigger number, or rather the number that gives me bigger concern, is the 205 people who have been judged not to appear to meet conditions C, D and E of the Act, and a further 25 people who only have convictions for an offence that doesn't meet conditions A and B of the Act. So that's 230 people. Now, what Mrs. Eaton's evidence suggested to us is that those people had been judged as not qualifying, but in the letter that you wrote to me before Christmas, you said that those people were not being written to tell them that someone had taken a decision that they didn't qualify. Now, obviously, what that then gives rise to is a very significant risk that because of the data issues that you've got, judgments are incorrect, and there is no formal, established, transparent, clear, overseen appeals process which can ensure that these injustices do not arise in the future. So, in the light of Mrs. Eaton's case, what steps are you taking as a minister to ensure that there is a transparent appeals process for those who have been considered and judged not to meet the requirements of the Act?
So my understanding, Chair, and I will refer to officials if that's not the case, is that these individuals have been told, but they haven't been told that they are completely out of scope, or they haven't been told that they've been judged totally out of scope. All we have told them is that there is currently not enough evidence to rule them in scope. So they haven't had the door slammed in their face. I want to make that very, very clear.
Just before we bring in Christina, if that's what you want to do, I just want to point you to the evidence in paragraph 5 of your letter to me before Christmas, which says this. It says, "We believe that it would be insensitive to write to these individuals, as we believe they would know their convictions are not in scope of the Act." Frankly, that sentence terrifies me, because it seems to imply that you've taken a decision about somebody in secret, not told them and not asked them if there's anything further that you should consider. So can you assure me and this committee that there is an appeals process that people can lean into once you've taken a decision on their case?
Yes.
Yes, absolutely. And if I can clarify, the only people that we're not writing to are the ones that do not have a conviction. So their conviction has already been, they were found not guilty originally, or their conviction was overturned by the court. Otherwise, we are writing...
That's 120 people, Christina. 101 people, individuals who have had convictions already quashed by the courts, 19 individuals who have only had convictions already considered by the Court of Appeal. Is that correct?
Out of the 390, we have written to 196 to notify them that they have been assessed.
Okay, I'm more worried about the 230 people who you've said in your table are individuals judged not to have convictions to meet the tests in the Act. I want to make sure that we've got an appeals process that is open to them.
Yes, and we do.
Okay.
And just to confirm, we are writing to the 25 individuals who only have convictions for an offence which does not meet conditions A or B of the Act. We are writing to those people. And we are writing to those who we have we understand from our data that they have convictions that were brought by prosecutors other than Post Office or CPS, because if they can tell us that that's not the case, we should know about it. So we are writing to those, and we are writing to those who only have convictions already considered by the Court of Appeal, in case there is more information that they need to make us aware of. Those we are not writing to are only those where we have information that show that their convictions have already been quashed or that they were found not guilty.
Yes.
And so just for the record, how many people is that?
205. Is that correct?
No.
So that's the 205 in C, D and E.
Yeah.
We're writing to the 25, the 28 and the 19.
Okay. And so you are writing to the 205?
Yes.
Yes.
Right.
But there are a number within that 205 for whom we are struggling to find a verified address.
We will get you those figures, Chair.
Thank you. And Ms Bance, do you want to just lean in on that?
Thank you very much. Can you tell us a little bit more about this appeal route? How do potential claimants, people with further information, find out about it? How is it publicised?
So because we know at no point is the decision firm, it's not a final decision. So what we do is we write to them and we say, on the evidence that we have available to us, we have been unable to rule you in scope of the Act, but if you can give us more information, then we will take that into consideration. We give them all of the information in terms of which conditions we have been unable to find information from, about, and we invite them to provide us with more information where we are struggling to fill those gaps.
Okay.
Thank you. But
please.
So, is this process of writing to these people in this table, the 205, the 25, the 28, is this a new process post Mrs Eaton's experience? Because Mrs Eaton wasn't written to, and therefore the appeal process which you've set out was opaque to her. She couldn't access that process because she didn't get the letter to say that she had been assessed. She was just not contacted.
As soon as we assess somebody and we reach the point at which we don't have any more information, we write to that person.
Okay. So there is a discrepancy here with how Mrs Eaton didn't receive communication.
Yes.
That we need to find out.
There was, right.
Because she should have been written to.
She should have been written. Under what you've said to us, she would have been included, I'm not quite sure in which of these categories, but she would have been written to.
Yes, that's correct.
But she wasn't.
Yes.
Okay.
We're slightly concerned that the evidence that we've taken from legal teams today suggests that there isn't a clear and transparent appeal process. So you're assuring us that there is?
Yes.
Okay. So perhaps in an exchange of correspondence we can just document that and make sure that the world knows about it.
Yes.
Anything further on that point, Ms Bance?
I want to be sure that there aren't any people outside the 1002 that may be eligible.
There are.
There are?
Yeah, potentially. And these individuals are self-identifying, they are coming forward themselves, they are coming through to us and they are being assessed individually.
Okay, thank you.
And there's no deadline?
No, there's no
it's
close.
a permanently open scheme?
Yes.
Right. Thank you very much indeed for bottoming that out. Mr Cooper.
Thank you, Chair. If I can come to the DBT team, we've heard some toe-curling evidence today about the HSS scheme, the Horizon Shortfall scheme. It does seem to be coming to the end of its natural life. It has had some success in clearing up what we might call the simpler cases, and simple nonetheless, the victims suffered horribly. Do you agree that that system is broken? And if you do, why wouldn't you take it in under your own DBT HSS appeals scheme and take it out of the hands of the Post Office?
So I would agree that we inherited a broken system. I think where I slightly depart from some of the evidence earlier on is that I think it can be improved, and I think it is being improved. HSS over the course of the last year went from, I think, 47% of claims paid at the start of the year to 79% of the stock having been settled by the end of the year. And that's despite us walking, or rather the Post Office walking up a down escalator, as it were, because 5,000 more cases joined that stock over the course of the year. But I think we absolutely accept, I think, the characterisation from the legal representatives earlier on, that there are quite different experiences in that between perhaps if you've gone through the fixed sum offer route than if you had a more complex or contentious case. But that's exactly why we have put in place HSSA as an appeal route.
And one of the evidence that we've heard today, I mean, astonishing figures, the difference between the HSS awards offered by the Post Office and then the awards put forward under your appeal scheme, and incredible figures. The Chair mentioned the fivefold median, which is jaw-dropping, and we've got evidence of a specific example where the original offer was £101,000 in round figures, and yet the offer from you was over £1 million. It's incredible. What do you think lies behind that? Was this a deliberate attempt to make low-ball offers at the start?
No, I think as you say, the HSS as a system hadn't worked well. Just to pick up on something that was raised in this earlier on within the evidence, when HSSA do make payments which are significantly higher, we do a report back to the Post Office on the reasons for that and the process behind that, which is about improving the process for those who follow. Because we don't.
That doesn't seem to be happening, though, does it? I mean, you are providing feedback.
Well, it's a relatively new scheme, HSSA. So we are working on that. And just to come back on something else, I think that the Chair and others had raised earlier on with regards to this. I know the Chair in particular was concerned about the original stock of the original claimants within HSS. And about those being transferred over to HSSA, which was raised by witnesses earlier. That is happening. Of the 286 original claimants who have had offers and are sitting there in HSS, 228 of them have transferred over to HSSA. So that is happening.
When was that, Minister? When were they transferred over?
I'll turn to Carol for that, I think.
Yes, over recent weeks. So the scheme so far has had 315 people passed as eligible, and within that is this group of 286. We've had 80 complete claims, and we've issued 31 offers. So it's early days.
These were the claims that had made, frankly, almost no progress between January and November.
They've been sitting there unhappy with their offer, but now the appeal system is open. People are moving over, and they're still able to do that. The door is still open for claimants to move out of the Post Office into the HSS system.
Right, so you're comfortable it's not going to take 6.5 years to resolve those cases, which is what their current speed would suggest?
Well, as the lawyer said to you earlier, we are providing offers on those HSSA cases very promptly once we get them, so we're doing well against our 40 working day target. So that's correct. Once those claimants have put in a full claim, and they do require some material from Nigel Welton's team at the Post Office in order to do that, we will then give them an offer.
But we've got to do two things. I mean, we've got to get HSSA working well, but we've also then, as I say, got to make sure the lessons from that are passed through into HSS so that fewer people get into that position of being unhappy.
We've heard lots of people express the hope that 26 might be the year that we finally get to the bottom of all this, but equally we're hearing that more cases are coming out of the woodwork, as it were. Have you got a target for a date for when all sub-postmasters will actually have this settled and paid?
We're reluctant to set a target like that, not because we're seeking to sort of avoid accountability, but because we're dealing with pretty vulnerable people and traumatised people within this. We have within HSS, with the closure at the end of this month and the milestone of getting to a point where we are clearing more cases than are coming in, you can start to see that pathway on that scheme. With GLO, we're seeing quite high-profile cases settled. We're seeing more and more people moving into the panel stage as well. So there is a feeling that we're moving into a different phase with many of the schemes. And as the Secretary of State said to the committee just before Christmas, I mean, it is our intention to make 2026 that year where we get through the bulk of those. The caveat and the caution I would put to that is we're obviously launching 2 other schemes as well. So there will be new claimants coming on to the stocks within Capture and within the family scheme. And again, just to return to that point, that not all of this is within our control, and we are dealing with very vulnerable people who we've got to be sensitive with as we do try to progress and finalise and conclude these schemes.
May I just illustrate that with one fact? We are still waiting for 22 full claims from those people whose convictions were overturned by the courts up to 4 years ago, sometimes 5. So these are vulnerable people who have still not, with their lawyers, submitted a claim. That's claimants that used to be managed within the overturned conviction scheme and now within the Horizon Convictions Redress Scheme. Yeah. And similarly with the GLO, we're still waiting for 16 full claims. So it's a bit of a demand-led system, and we will respond once we've had the claim, which is why it's a bit hard to say when.
Say it's demand-led. Are you reaching out? I mean, I appreciate the sensitivities here, but are you reaching out? Are you actively chasing these? You're almost aware of these cases. Do you actively chase them up and try to, for want of a better word, chivvy them along?
We absolutely do. So to take the GLO group as an example, we know who is representing which legal firm. The 2 that you saw earlier, plus Freeths in the main. We know who is representing each of those 16 claimants, and we talk to them very regularly about where the claimants are in the process. And what they very often say to us is that they are finding that some of the claimants are waiting until Sir Win produces his final report. Some of them are very vulnerable, and it's difficult to take instructions from them. But we do regularly talk to the lawyers who represent them, yes.
Yeah.
Thank you, Chair.
Sarah Edwards.
Thank you, Chair. We heard in earlier evidence that the Post Office are supportive of transferring the HSS scheme over to DBT, but they did cite the sort of time frame that we've got about a month until the current application deadline sort of closes. So are you in discussions? Have you decided that is what you're going to do? Where do you sit on that at the moment?
I don't want to come across as close-minded on this, but Sir Win in the inquiry looked at this in depth, and his argument was if you look at what the Post Office does within Horizon, so identifying eligibility, no one has the information other than the Post Office to ensure eligibility, paying out the fixed sums, and nobody feels there's a particular problem, I don't think, in getting that done. And then when you get to the decision-making part of it, the panel, that is already independent of the Post Office. My slight concern with suggestions about sort of wholesale moving people over to HSSA is that HSSA was set up as an appeals process for HSS. You would then lose the appeals process for HSS and have to set something else up, particularly because it's not particularly good practice to have the appeals and the decision-making process in the same place. And the final thing just to say on that is we do not in DBT have the staff or the expertise to do what is happening in HSS at the moment. It would create a significant pause in redress at a point at which, for all of the faults within Horizon, for all it being a broken scheme, it is delivering large numbers of redress at the moment. So as I say, I don't want to appear entirely sort of close-minded on this, but the judgments we're making, similar to the judgments that Sir Win have made, are about getting full and fair redress to people as quickly as possible through this.
So you're not going to take it on at all?
Well, the complex cases, as I say, are coming through to us through HSSA anyway, so that is helpful, and we are taking a whole lot of other measures to make sure that HSS works better. I think the most significant one, again identified by Sir Win, also from this committee, is around Sir Gary's new role as a sort of troubleshooter to make sure that, as happens in some of the other schemes, there is someone as an independent figure there to sort of bang heads together, drive things through in difficult, complex cases, and get things done more quickly. But as I say, on top of that, having HSSA there is, I think, a significant change.
Okay, because some of the data that we've seen, sort of shows almost like a tenfold difference between what the HSS redress was, so 100,000, let's say, to 1 million, which is what the HSSA has concluded should have been, the correct redress. So, given that, I think we've got about 13% or something left of those cases that still need to be dealt with. So, would it not make more sense to have a different set of people? Because if you've got such discrepancies, then it's sort of like, well, we'll continue with this, and then we're just going to move them across to the HSSA anyway. So,
Yep.
I just don't quite understand the logic of saying that you're not going to sort of review the fact that it clearly doesn't really work, does it?
But again, HSSA is an appeals process. So if we move people over wholesale, you would then need to create another appeals process. The other thing to say is, I mean, there's an element of this which is the figures should be higher when people go to HSSA, because by nature of it, it's people who are unhappy and aggrieved with the offers that they've got. Now, should there be as big a discrepancy as there is? Absolutely not. But that goes back to what I'm saying about all the other measures we're taking to make sure that HSS works more effectively, including, for example, a new information service that we provided and put in place from last month to make sure that more of the information is there. We're working very, very hard to make sure that the information is collated properly within the scheme.
May I also add that it's not the case that 100% of the HSSA offers are larger than the HSS offers. So some of the offers that have come out of HSSA aren't higher than the HSS panel. The lawyers have obviously handpicked some examples to give to you, and it is true that the majority of the HSSA offers are higher than HSS, but in some cases they've even been lower than what it was in HSS, in which case we honour the higher amount that the victim has been offered.
It's a significant number, though, that the discrepancy, it suggests that the system doesn't quite work. And I think what the sub-postmasters have been very clear about is that there is a huge conflict if the person who is determining the amount of compensation to be paid out is the person that has perpetrated, the entire scandal. So I think there is a good reason to be questioning that system. And yes, we are quite far down, but I think we can probably say it wasn't great. So are we not going to just sort out these final 13 or so % of claims and do it the right way first time round, in which case what pressure is being put on to make sure that that scheme is going to deliver if you're not going to take that in-house?
So, as I say, we have Sir Gary there as a troubleshooter, and that within Sir Wynn's inquiry recommendations was the single thing that he thought would make a difference. Having looked at those similar roles in other schemes were the things that made the difference with the contentious cases. I would say on top of that, all the other existing things that have got things moving in a high volume in terms of fix some offers, improving the amount of advice and support that's there all the way through it is really important. And again, just to go back to when HSSA is making higher claims, when there has been that gap in information, is going back to HSS and making sure that the lessons are learned from that. And in addition to those sort of slightly more formal things, I mean, we brought in representatives of the victims into the cabinet room just to sort of symbolically show that their voices were heard at the centre of government. Following up from that, we had a meeting with all the lawyers from all the schemes together to try to identify some of the things across schemes which were slowing things down. One of the things that's come out of that we're working on at the moment is a sort of clearer set of guidance for when there has been an offer that's been lower than people's expectations. Here are common examples of information that was lacking to do that. That's important because it helps make sure that the offer is better. It's also about not re-traumatising people who already felt that they were constantly, years ago asked questions and not believed. Because when we do go back for more information, it is about trying to increase the offer to people, but often that feels like it's a sort of inquisitorial doubting of their case, when actually what we're trying to do is fill those gaps in information.
Let's just try and give this one more go. So there's 2,747 claims still outstanding at the end of November 2025. The chairman of the post office has just told us that they can deal with about 80% of those by summer next year. That leaves about 550. You're saying today that you don't think those 550 should be transferred to DBC, they should stay with the post office?
Yes.
Okay. And is your mind closed up now on that?
My mind isn't closed. I mean, we're constantly working with the advisory board and others to make sure this works.
That's good, because the chairman of the post office disagrees with you about the best approach to that. The second issue, though, is on the HSS redress data. So total claims received 378, total claims paid 1. So why are the number of claims paid through HSSA so low?
Can I give you the breakdown of that 378?
Course.
So we've had 378 registrations. People have
I have it in front of me. So you've
Yes.
got 80 claims in, total offers made 31, number of claims without offers 49, total offers accepted 1, claims paid 1, total claims paid as a percentage 1.25%.
Yes, and so the figure you missed out was the 315 who have passed eligibility checks.
315?
Mm-hmm.
Who
have passed eligibility checks.
Yeah.
Once they pass eligibility checks, we request disclosure documents from the post office, which enables them to put together the application form for HSSA, which is what has then moved us to the 80. The 80 complete claims have followed on from disclosure that has been provided to the lawyers representing those claimants.
Right. So you can't be happy with that number. So I think the question for you, Minister, is what are the steps that you're now going to take over the next 3 months to turn that 1.25% into 100%?
Well, we're working very hard on that. It is a new scheme. We're constantly learning lessons from it. But I think, in fairness, as the lawyers indicated earlier on, this is a step change in terms of the culture and the feel of redress schemes compared to what's gone before.
Okay, we will supply you with further advice of our views on that. Let's turn to the family redress scheme now, Mr. Aldridge.
I'm going to ask something slightly different before we move on to that.
Yeah.
And I'm just going to declare an interest as a former employee of BCS, the Chartered Institute for IT. So the Horizon scandal, for many of us who work in that area of IT professionalism, it acted as a bit of a canary in the coal mine, indicating future risks if we don't learn from this and implement systems that are better. So private sector are owning a fast increasing share of public risk. IT systems and services administered by private companies are at the heart of that risk and that liability. The potential fallout for core public services like NHS, energy, all the rest of it, it's actually quite existential, as we're seeing here in the post office. The culture, accountability and assurance frameworks are woefully inadequate to meet the challenges. So why, at least in areas like critical national infrastructure or significant public service provision, do we not require the highest standards of chartered professionalism and accountability and ethics like we do in areas like accountability, building, medicine, etc.?
I think it's a very good point, well made. And one of the things I feel a sort of sense of responsibility for is someone who will likely be Minister of the Post Office at the point at which Sir Wynn's next report, which will look at issues of accountability and how to institutionalise lessons around this, is that will be my responsibility. I think the issues you raised would obviously, I think, be a matter for Cabinet Office in terms of procurement, but I'm very happy to go away and talk to them about how could we, through that process, enhance those ethical standards.
Thank you,
Mr. Manners.
Thank you, Chair. Mr. McDougall, you and your predecessors have always said time for accountability and a portion of compensation in terms of Fujitsu's contribution will come when Sir Wynne Williams' recommendations come forth. So I take it from that you are confident that he will express them in a way that allows you to do that?
We don't know. We'll have to wait and see. I think just to follow on from the witness from Fujitsu earlier on, I mean, just to say we have we had a constructive conversation, but left them in no doubt in terms of the need for a substantial and significant contribution, and reinforced that their reputation as a company, both within Parliament and the wider public, would depend upon that.
Okay. If Sir Wynne doesn't produce the recommendations in a way which gives you a nice sort of straightforward percentage, for want of a better description, to provide to Fujitsu, have you given any thoughts as to how you might start to construct something?
The short answer is no. I mean, I wouldn't expect Sir Wynne to be have a table with percentages of blame apportioned. But I think we will have to properly digest what he concludes in terms of individuals and institutions that have responsibility for this.
But when you give the bill, for want of a better description, to Fujitsu, you're going to have some sort of rationale for it. So are you looking at and thinking about how that might be constructed?
We're in constant discussions about that, but I think it'll be very difficult to put a very precise metric on that.
Okay. And in terms of the figures, we've obviously got the 1.8 billion compensation. That's your starting point for conversations. But will there be other areas of financial compensation that you would look at? For example, the millions that must have been spent on lawyers and accountants and IT experts by all the bodies. Is that something that you would add into the mix?
That's certainly the starting point in terms of thinking about the cost of things. I think in terms of the figures, there's the £1.8 billion figure. I think I'm writing in the budget there was an additional about 250 million, which is covering capture and other legal costs in terms of running of the establishment of schemes.
And have you sort of looked at the overall cost to the public person in terms of not just government departments but outside agencies of dealing with all this? Has there been any effort to sort of bring that together at this stage?
I mean, the sort of working number within the department is around £2 billion. But as you know, the Treasury have been at pains to make sure that it's clear that the amounts that are budgeted for this they're not a ceiling, that we are going to make sure that people get the full and fair redress, and it doesn't have a ceiling on it.
So just moving on to government contracts, obviously you will caught the exchange that we had. My interpretation, and this is for you to agree or disagree, is that when Fujitsu are bidding for new contracts which may be of a previously existing service, that is in a sense a new contract. Would you agree with that analysis, or do you think that is erroneous?
I don't think I particularly want to dance on the head of a pin on that. I mean, for example, we out of necessity have extended, for example, the contract for Horizon while Post Office work on the successor system and seek to procure on that later this year. I mean, we could get into debate as to whether that's a new contract or not. Well, look, but the overall point for government is that is whether Fujitsu will only bid when asked by government.
Okay, and so for the hundreds of millions of pounds of government contracts that have been issued in the last 18 months, you're confident that every single one of those was absolutely necessary to be issued? The only way it could be delivered was through Fujitsu?
Well, to take the example of the Horizon extension, if we hadn't done that, every post office would have to close. Okay, that's a good example of the type of judgment we're trying to make.
So you're saying that would apply to every other contract that's been issued to Fujitsu, since that actually that's the only way the service or whatever it is would be able to continue?
Well, I mean, it'll be for other departments to be accountable for the contracts that they have run. I mean, when you look across Whitehall at the systems they do run, there are Home Office border control systems, systems about communicating with submarines. I mean, things which are absolutely critical to national security and national infrastructure. So I absolutely get the discomfort around this. I get how it sticks in people's craw. But that is the context to it. These are incredibly important, incredibly difficult to replace systems.
Your position essentially is that we've had to do it, and there really wasn't any other way for all these contracts. Could I just come back to the provision that hasn't been made yet by Fujitsu? Are you in any way discomforted by the fact that they don't appear to have made any accounting for this so far?
I mean, when I became Minister, I was surprised that there hadn't been interim payment. I mean, my predecessor had pressed Fujitsu on this, and the position was restated earlier on. I asked about that in the meeting as well, and their position is obviously that they are waiting for Sir Wynn's report.
Okay. Just to wrap up then, we've heard some pretty disconcerting evidence about capture this afternoon, and we've had the head of the CCRC say that it would be wise for Parliament to reflect on extending the overturned conviction schemes to include capture victims. Minister, what's your view on the wisdom of whether Parliament should indeed reflect on this?
When Parliament took the unprecedented decision that it did to legislate to overturn the convictions following Horizon, it was because it was an exceptional situation. Over 100 cases had been overturned in the courts before Parliament took the very, very unique position that it did to legislate for this. It would be quite the constitutional stretch to do that again, unless it was exceptional circumstances. There have to date not been any convictions overturned as a result of the capture system. As you heard from the chair of the CCRC, there are 35 cases which they are assessing. They are under new leadership. Dame Vera Baird has also taken the reins there, and they have a very good assessment rate. 85% of the cases that they assess are now closed and looked at within 12 months. Given the number and given the nature of the capture cases thus far, we do not think it would be appropriate to extend or to legislate to overturn those convictions. We feel the appropriate vehicle and mechanism is the CCRC.
What would change your mind?
Numbers or more evidence showing that that was not the case, as was the case in Horizon. As I said, over 100 were overturned by the courts.
As in numbers of overturned cases at the Court of Appeal?
Yes, and to date there have been none relating to capture.
Okay, thank you very much indeed. Thank you very much indeed for being clear and candid, and thanks very much for the grip on the numbers that you've had this afternoon. That is much appreciated. We will reflect on what you've said before we send you our report in due course. That concludes this session. That concludes this panel. Order, order.